areas related to the changes. I'm going to look at some key areas related to those changes and some practical ways that you can ensure your businesses are as protected as possible against any civil penalty. And we'll talk more about civil penalties in due course. So let's run through the agenda for today. So we're going to look at why we need to check an individual's right to work. So why do we do it in the first place? What's changed and what that means for employers when conducting right to work checks. How we can be consistent and compliant with right to work checking. And those two words, consistent and compliant, are going to feature fairly regularly in this presentation. What we need to do if an employee loses the right to work in the UK or didn't have it to start with, and what we need to do with our existing employees regarding right to work checks, because there is some stuff that we also need to do for people who are already employed by us. The chat facility is open, and if you have any questions during the course of the presentation, please feel free to drop them into the chat. My colleagues Julie and Sarah will be monitoring those as I'm presenting, and we'll pick up any questions at the end that are feature in the chat. And we'll also be using the chat to drop in some websites for you to access after the webinar, which will be referred to during this session and that you would find perhaps useful in your right to work checking processes. We're going to keep everybody on mute whilst the webinar is in process, and then open up the mics at the end for questions and answers. Because there's quite a lot of people on this webinar today, which is amazing, and thank you so much for signing up for it. It's probably going to be easier if you do have a question during the Q&A, if you can just put the raise your hand signal so that we can know who's asking the question. The session is also being recorded, and it's going to be available through the Kingswood Group website later on. That's www.kingswoodgroup.org. So let's have a look at the first of our agenda items. So why do we check right to work in the first place? Well, as you are possibly aware, and maybe not, but all employers in the UK have a responsibility to prevent illegal working. And we do this by conducting right to work checks before we employ someone to make sure that they have that they are not disqualified from carrying out the work in question by reason of their immigration status, as well as we can check during their employment if they are on some sort of time-limited immigration status, for example, a visa. To ensure we're not discriminating, we must conduct checks for all prospective and current employees, which includes British and Irish passport holders, and not exclude them from any checking process to avoid that claim of discrimination. We should never be making assumptions about the genuineness or otherwise of a person or any documentation, whether that's someone presenting in person or checking via the online systems. By carrying out right to work document checks correctly, companies are able to rely on what's called a statutory excuse against alleged breaches, providing that they can demonstrate that they have taken consistent and compliant measures to ensure they are only hiring individuals with the permission to work in the UK. Conducting either the manual-based document check or the online check, which we'll discuss in this webinar, consistently and compliantly will provide you with a statutory excuse against any allegation by the Home Office of a breach. And that's really important, and we will talk about that. So why does that matter? Well, let's have a look at what could happen if you didn't do it right. The law says that if you have reasonable cause to believe that someone currently working for you no longer has the right to work and you continue to employ them, or if you employ someone who, based on their immigration status, does not have the right to work in the UK, and you have not conducted reasonable checks and yet you continue to employ them, you may become liable for a civil penalty. It's a criminal offence for employers to knowingly employ an illegal migrant worker, and it's also a criminal offence for employers to employ an illegal migrant worker where they have reasonable cause to believe that that individual does not have the right to work in the UK. So that's either somebody already in your employment or someone prospectively about to go into your employment. In those instances, the employer could incur unlimited fines imposed by the Home Office, and furthermore, individual directors or senior managers who know or who consent to the illegal employment of those workers may also be convicted and face a jail term. So just to warm up your right to work brain muscles, I'm going to set up a little poll now, and the question is, let's just open up the poll itself. So what is the maximum civil penalty or prison term an employer could face if found to have knowingly breached the right to work rules? Is it up to £5,000 per illegal worker and 10 months in prison, up to £10,000 per illegal worker and up to 2 years in prison? Or is it up to £20,000 per illegal worker and up to 5 years in prison? If you'd like to select your answers, and then we'll share the results. Okay, everybody has answered. So let's just share those on the screen. Hopefully everybody should be able to see that. So as has been correctly identified, well done everybody who said £20,000 per illegal worker and up to 5 years in prison. That's absolutely correct, which is quite a daunting thought when you think about it. So aside from the £20,000 and up to 5 years at Her Majesty's pleasure, what other risks are involved in employing illegal workers? So breaking the law in relation to the right to work can jeopardise your employment status as a registered sponsor. So if you have a sponsorship licence, which enables you to bring overseas worker in on that sponsorship agreement, that could be put at risk, as well as putting the individuals who are being sponsored, whether they are illegal or otherwise, also at risk. Employers may also be subject to an illegal working closure notice and an illegal working compliance order, both of which put either a closure or a restriction on your ability to operate as an organisation. And those individuals who are found to be working illegally may also be guilty of an offence under the regulations and may be subject to imprisonment and/or a fine. So what's the conclusion to all of that? Well, we all want to remain on the right side of the law, so it really pays to conduct these checks fairly and thoroughly and whenever necessary. So let's have a look at what changed and why. So on the 6th of April 2022, the Home Office launched new guidance and also a code of practice, which requires employers to check a person's right to work by conducting either a manual or an online check of the relevant documents. Now, some of this stuff isn't brand spanking new, but it has been changed, and it's really important, which is why we're running the webinar today, that we give you as much information so that you can support yourselves in and around these manual and online checks. The driver for this change was primarily Brexit, it has to be said, but the pandemic also had a significant effect on how right to work checks were being conducted, both during the periods of lockdown and subsequent to it. During that lockdown period, during the lockdown period of the pandemic, the Home Office introduced something called adjusted checks. And these were right to work checks which were conducted remotely. And anybody who was recruiting during that time will probably remember that. Employers could ask the individuals to submit a scanned copy or a photo of their original documents via email or using a mobile app. Then they would arrange a video call with the person and ask them to hold up the original document to the camera next to their face so they could be checked against the digital copy of the documents. The employer would then need to record the date they made the check and mark it as, in quotes, adjusted check undertaken on whatever the date was due to COVID-19. Now, this was due to cease at the end of March, but has now been extended until the 30th of September. And the reasoning behind that is this temporary extension is to allow more of the new identity service providers, the IDSPs, to be launched and adopted by employers. And I'm going to talk a little bit more about IDSPs as we go through this webinar. There are discussions at government level about retaining the system of adjusted checks to assist with some types of recruitment, for example, recruiting people from overseas. And if we get more evidence of that becoming a concrete reality, then we will keep you posted. So adjusted checks aside, the changes implemented on the 6th of April now give employers 3 primary methods for checking an individual's right to work. That's the manual right to work check, which is conducted in person, the Home Office right to work check, and the digital right to work check using identification document validation technology, IDVT, using the services of an identity service provider, an IDSP. Lots of lovely initials, which are real tongue twisters. The 3 options will, if you apply them correctly and in accordance with the Home Office's code of practice, provide you with a statutory excuse, which is the really important part. That's that will give you the protection against civil fines and liabilities. The first is the manual in-person check, which can still be conducted for British and Irish national citizens who hold a valid passport, including Irish passport cards. You can also check British and Irish nationals' right to work status using an ISDP if you have one of these in operation within your company. British Irish nationals who are going through an IDSP for checking their right to work do not need to use a share code for this purpose. And we'll talk about share codes as we a little bit further into the presentation. Share codes are only to be used for foreign national workers to enable employers to check their right to work using the Home Office online checking service. When you are checking documents, one of the most important things is it is not just a cursory glance. In order to check a document and to maintain a statutory defence, you must ensure the full three-step guidance to obtain, check and retain the right to work documents is followed. The second way, checking via the online right to work system, is where you would look the individual up via the Home Office right to work online service. And Julie's going to drop the website into the chat for you. You can access now or access later. We will also be ensuring that those get sent out to everybody who's participated in the workshop today. And you would go to do that, you would need to check somebody online, you would need to obtain their share code, which they have to obtain for themselves via the gov.uk website, and you would also need their date of birth. The share code is usually valid for 30 days, and it will comprise 9 alphanumeric characters. When you have their date of birth and their share code, you can go onto the online system and check their right to work. The third way is via a digital right to work checking service, as I've mentioned before, the IDSP for British and Irish nationals. Now, you can use the identity checking part of that service for non-British and Irish nationals, but it will not give you a statutory defence against illegal working and claim for anyone who is a migrant worker or a foreign national worker. So IDSPs allow employers to verify an individual's identity. That is, they are who they say they are, regardless of nationality. But they cannot yet be used to prove that right to work, as I've said, in the UK to satisfy that statutory defence. You will obtain a statutory excuse where you can demonstrate that the provider has complied with all the statutory requirements. And at the moment, that just isn't in place for foreign national workers, only for British and Irish nationals. Should anybody be found to be using an IDSP and using that as proof of right to work for anyone who is either a British national or an Irish national, will not have the statutory excuse at this time against a potential breach of the immigration rules. So employers will need to be able to rely, that do rely upon this service to be able to prove right to work, really should only be looking to use that for British and Irish nationals to prove right to work, and using it for anybody else to prove identity. ISDPs, for those who aren't as familiar with them, are independent organisations who have set up a service through an online portal, and for a fee can complete identification verification elements of the checks, and are certified by the government as being eligible to providing identity, right to work and DBS checks. There's not currently a lot of information about whether the government will seek to regulate or control the various IDSP providers right now, but there is a view that that is going to come in time. What is clear is that the service of these IDSPs is not free. There is a charge to the employer, anywhere between £1.45 and £70, depending on the provider, the volume of checks run, and also the type of check that's being conducted. As with all things, the provision of this service is still a work in progress, and it may be in time that these costs will come down. There are already providers on the market who have started the checking process with a number of employers, but it's not widespread as yet. For now, you can continue to do manual checks for British and Irish nationals, but there is a bit of a kind of a health alert on that, is that there are also suggestions that in time, in-person manual checks will also be phased out. Again, watch this space. We will let you know if we hear any more. So before we move on to look at the 3 types of checking processes in more detail, the check, obtain and retain, I just want to highlight a bit of a point about discrimination during the right to work process. So, as I'm sure you all know and are very familiar with, the Equality Act 2010 clearly set out the 9 protected characteristics which prevent discrimination in any way, shape or form. And being consistent with the right to work process and ensuring that you are paying attention to this will avoid a lot of trouble. So no group or individual should be treated differently because of a protected characteristic. And in the case of right to work, in this instance, relates to race, which covers nationality as well. It's unlawful to discriminate against individuals on the ground of any of these protected characteristics, including race, when you are conducting the right to work checks. So, for example, if a candidate was subject to a right to work check, but witnessed others not being treated in the same way, perhaps because they were British passport holders, they may feel that they have been subject to unlawful discrimination on the grounds of race and may bring a complaint before the court or before the employment tribunal. If their complaint was to be upheld, the tribunal would normally order the payment of compensation, for which there is no upper limit. There is a separate code of practice for employers called Avoiding Discrimination While Preventing Illegal Working, and Julie will add that to their website chat for us now. That gives you further information and advice on how to operate a checking process that is non-discriminatory and in accordance with the statutory equality duties. You should apply the same checking process as part of your recruitment policy and extend a right to work policy for all employees, whether or not you may believe that they have the right to work in the UK. You should still be taking the same. No assumptions should be made about a person's right to work in the UK based on their race, ethnicity, their accent, their age, the time spent living in the UK, family connections, or indeed their education. A past experience of mine was being told that I did not need to check a particular employee's right to work as she was, quotes unquote, clearly British and not a risk. My counter to that was therefore that anybody who didn't look clearly British would be a risk, which would obviously be a massive discrimination. So no assumptions should be made. Using the code of practice to inform your practice in conducting robust right to work checks will ensure that you are non-discriminatory in your approach. So let's move on to the 3-stage checking process that I spoke about that the Home Office has set out by way of expectation. They set out that that employers will manage consistently and compliantly. It's those 2 words again. And in order to be consistent and compliant, it means going through a very sort of robust process to make sure that you are doing the same thing each and every time. The 3 stages are to obtain, to check and retain, and we'll go through those now together. So firstly, in obtaining documents, to commence any right to work check, obviously the first step is to obtain the correct documents. And by the key word in that is correct, the word correct. So this must happen this can happen during the recruitment stage at any point, but in any event, it must happen before the first day of employment. It cannot take place after the first day of employment, on or after the first day of employment. Documents that prove identity and right to work should always be checked manually first before being subject to an online check. If you are checking a British or Irish national's right to work, you can do the manual check in the presence of the document owner. And if you're satisfied that the right to work is proven, you can stop the process right there. Only documents from the Home Office right to work checklist are permitted, and Julie's going to drop into the chat the website for the updated Home Office right to work checklist, and you will use that when you're checking British or Irish nationals' right to work. The list is now divided into 3 sections. List A covers any List A documents relate to the initial pre-employment checks that you would do, and that you would not be required to carry any further right to work checks on this particular person, as the documents that they provide from List A would give you a continuous statutory excuse for the full duration of their employment. List B Group 1 means that there is a time-limited statutory excuse in place, which will expire when the individual's permission to be in the UK expires, and you should carry out a follow-up check when the document evidencing their permission to work expires, ideally before then. List B Group 2 means that you have a time-limited statutory excuse which expires 6 months from the date specified in your positive verification notice. This means you should carry out follow-up checks before this notice expires. So for the purposes of what is a positive verification note, these can usually be triggered by the employer undertaking a search on the Home Office website for the employer's checking service, which allows you to go on and check whether the individual has the right to be in the UK. Now, it could be that they are subject to an application. It could be that they are that they just don't have the documents because of the length of time that they have lived in the UK. And what you will be given is a 6-month period, if you like, for protection under the statutory excuse on this positive verification note, during which time you should be carrying out your investigations to find out, what the current state of play is for that particular individual, and to make sure that they do have the right to work in the UK, and that you can then continue to employ them, which is obviously, a really important factor to avoid any of this sort of liabilities. All checks start with you requesting and being given the correct and legal documents by the individual for you to check visually. And all documents are going to need to be checked physically to ensure that there's no obvious signs of tampering or fraud, and must be the original documents. No photocopies are permitted. So if somebody comes to you with a photocopy, whether they are a foreign national worker or a British or Irish national with a photocopy of a birth certificate or a passport, then unfortunately you're not able to accept any of that, because it would not give that defence. The second stage in the process is the checking. And to check a document, you need to examine it really carefully. You're not expected to be border control agents, but you are expected to conduct robust and reasonable checks of the documentation, and not, as I've said before, give it a cursory glance. So you need to make sure as best possible that the documents are genuine, and that the person presenting them is the prospective employee, the rightful holder, and is allowed to do the type of work that you're offering. This would involve, scrutinising the document that's presented to you. And there's a simple 3-step process to follow. So the first thing is to look at it. I know this sounds crazy, but oftentimes somebody will give you a passport. You'll just kind of take a photocopy and give it back to them. You won't actually scrutinise the document in any detail, but you really should be. So check that the photographs and dates of birth are consistent across the documents and with the person's appearance in order to detect impersonation. This could be as simple as making sure that when you look at the person in front of you and you look at the photograph, that they actually marry up as best you can tell. As I said, you're not expected to be border agencies, but you are expected to look for obvious signs of impersonation. Check expiry dates for permission to be in the UK have not passed. If they are on a time-limited visa, that should still be in date. Check any work restrictions to determine if they are allowed to do the type of work that's on offer, and check that the documents are genuine to the best of your ability and have not been tampered with, and that they actually belong to the holder. Some useful tips around looking at things like the typeface on documents, such as on birth certificates, for any anomalies in the size of the font or the typeface will give you a clue as to whether it is likely to be authentic or not. Check the reason for any differences in name. So, for example, if the documentation that you have is for Mrs. Smith and the person in front of you is presenting as Mrs. Jones, what's the reason for the difference in name? So that could be due to marriage, that could be due to divorce, it could be change of name by deed poll. So ask for the other information to substantiate the differences in names. The second part of the 3-step check of documentation is feel. Does it actually feel right? So on a passport, if you run your finger around the edge, and hopefully you'll be able to see me doing this, it should feel aligned. There should be no dip between the paper and the outside of the passport. That's because documents like passports these days in the main are machine cut. Now, not all of them from other countries are, and there are a variety of different documents that could be presented. But if they are British or Irish nationals, they will have a machine cut passport. Also check, does the paper feel right? Do all the pages feel the same? Do some feel a bit thicker than others? That could be a sign that the document could be fraudulent. It doesn't necessarily mean it is, but it would be a red flag that you would need to look at in a little more detail. Birth certificates, we know, are typically printed on a certain type of paper. So if it's on some sort of flimsy paper or on a sheet of A4 that looks like it's come out straight out of a printer, then it's possibly not going to be genuine. If you want more guidance on spotting fraud, and unfortunately there are a lot of fraudulent documents around at the moment, then you can use the government guide to check in ID documents, which Julie will drop into the chat room for you now. And that will give you some guidance on how to check ID documents to the best of your ability. As I said, you're not expected to be border agencies, but you are expected to conduct reasonably robust checks. The third stage is tilt, and that doesn't mean tilt yourself. That basically means tilt the document so that you can look down the document to examine the holograms. Most modern passports and ID documents will have some form of hologram and watermarks. If you are able to acquire it, then using assistive technology for passport checking, which is in the form of a low-cost UV light box, that will show up any fluorescence and watermarks within the documentation. That's a really useful addition to have in your workplace to make sure that, that the documents are legitimate. If the document being presented is one that you're not familiar with or you're concerned about its legitimacy, there is a Home Office passport guide service that you can tap into, and Julie's going to add that to the website now. That's item number 5. And for foreign nationals, you're also able to check their original ID documents. Again, if you're unsure of their authenticity, there is a service called Prado. And I don't know if anyone has ever used the Prado website before, but it's incredibly useful for being able to look at time differentiated ID documents from other countries. So if you're presented with a passport, an Italian passport, which was dated this year, but when you look at it, it actually looks like an older style passport, you can go and check that on the Prado website, and it will be able to tell you whether that document was produced in the year that it's been used in. If it isn't, if there's a mismatch, then you know that you're potentially looking at a counterfeit document. Obviously, you're going to need the individual's permission to check the validity of their documents via the Home Office Right to Work checking service, and you would simply get that verbal agreement from them. You're going to need from your foreign national workers their date of birth and their valid share code, which will return to you either they have the right to work in the UK or they do not. If they are not willing to give you permission to check the validity of their documents, that is something of a red flag, and you would need to consider whether you wish to progress with the individual or not at that point. To be aware, from the 6th of April 2022, some of the old documents that used to appear on the Right to Work permissible list, ID document permissible list from the Home Office, have been removed. So now biometric residence permits, biometric residence cards and frontier worker permits have all been removed from the Home Office checking list. And you will not be able to maintain a statutory excuse if you don't check those individuals who hold those documents via the online checking service, even if the expiry date on those documents is later than the 6th of April 2022. The good news is you don't need to undertake any retrospective checks on anyone that you have recruited before that date, and where you relied on their valid BRP, BRC or FWTP to prove their right to work, providing you conducted a consistent and compliant check. That means that you have taken thorough and robust approaches to checking their right to work, which will enable you to maintain your statutory excuse. Instead of a physical document, such as biometrics resident permits, the Home Office is now increasingly issuing something called e-visas. And this is to enable individuals to evidence their immigration status. And you may be from time to time presented with an e-visa. These are mostly used where an individual has status or applied for settled or pre-settled status under the EU settlement scheme. But increasingly, they are going to be used for other immigration routes, such as the new graduate visa scheme. They would still require that you use the Right to Work online checking system via the Home Office. But if you do get presented with one of those, don't panic. It is just the new system, and it's worth getting a little bit more comfortable around those, identifying what they look like, but also remembering that you will still have to go through the Home Office checking system to make sure that it is the person does have the right to work in the UK. The third part of the process is reading the documents. And you have to make a formal record of the documents that you've checked by copying the documents presented. And by that, I don't just mean taking the document off the individual, popping it onto the photocopier, and then giving them back the document. As with the checking process, the photocopying or the copying process also has to be robust and thorough. You need to make a clear copy of the document and write next to it that in quotes, I confirm I have seen the original document on whatever the date is, and then you sign the first page of each copied document. If you are presented with documents after the person has, they say, oh, look, here's a copy of my document, but they send it to you after the event. Remember, photocopies are not permitted. You would have to be taking a copy of their document at the time the check is made. Retrospective checks and copying is not acceptable. The copy must be clear and in a format which cannot be altered or tampered with at a later date. So a photocopy or a photograph is acceptable, and that can be stored in hard copy or digitally. You need to make sure that the copy is clear enough to read and preferably in colour. Colour is quite important. If you've got the ability to do colour copies, then obviously I know that can be quite expensive to do that because of the cost of printer ink, but it is really valuable to have those copies in colour. And for passports, you're going to need to copy any page with the expiry date and the applicant's details, for example, their nationality, date of birth and photograph, including any endorsements such as work visas. For all other documents, you must make a complete copy in its entirety. So it's only passports where you can actually have part of the document rather than the whole document copied. So all the blank pages you can leave out. But for all other documents, you must copy them in their entirety. You need to keep the copies securely stored throughout the individual's employment and for a minimum of 2 years after they have stopped working for you. That again can be electronically or in hard copy, but you also have to be assured that you are in line with your own company's document retention and data protection rules. So it's worth, after the event today, checking that and making sure that you are maintaining those documents for at least 2 years post-employment. If you are approached by the Home Office inspectors as part of an authorised inspection to show the right to work documents, you must be able to present them on demand. The Home Office can attend premises on a pre-arranged or unannounced basis and request access to personnel records, and they can conduct interviews with employees, including HR, including the workers and including the management. The Home Office has the power to investigate employers to ensure that they are meeting their obligations under the Prevention of Illegal Working regime, and if they are licensed sponsors, that the employer is actually meeting its sponsor license responsibilities. So there is a bit of an issue sometimes when people turn up and they don't actually have any documents with them. What happens if someone you're looking to recruit cannot provide the documents or evidence their immigration status to check their right to work in the UK? Well, it's a system where you have to ensure that you have used the employer checking service. And if Julie can just drop that into the web chat now, to obtain a positive verification notice, which we've spoken about before. And this will provide you with a statutory excuse for up to 6 months whilst you undertake further investigation. Why they might not have the documents could be a whole range of reasons. It could be because they have an outstanding appeal, review or application with the Home Office, or perhaps because they arrived in the UK before a specific date. Or perhaps they just simply don't have them with them on that particular day. If no resolution comes within that 6 months, if they aren't able to provide you with the right to work documentation, you would need to run the checks again and be alert to the outcomes. And of course, that's that one of those factors is about non-progression of employment, which we'll touch on in a bit. Not having the correct right to work documents may not prevent them from commencing employment. And if your offer of employment and contract sets out clearly that their continued employment is subject to the condition of their right to work, and that continued employment is contingent on them having express right to work, you're going to need to review their employment arrangement within the 6 months if possible. So who do we have to check? Now, I've certainly worked in many organisations where the only people that got checked originally were people who were non-British or Irish nationals. Now, obviously, we've already covered that under the discussion around discrimination. So you should be checking that everybody who works for you has the right to work and continues to hold the right to work during their employment. Now, if you've done your right to work checks on a British and Irish national and you have been satisfied that their right to work is proven, you don't have to go back and check them again. You do have to hold their documentation, but you don't have to check them further. The obligation to check for people who are to ensure that they have the continuation of the right to work doesn't just apply to new employees. It obviously applies to people who are already working for you, who could be subject to a time limitation or some other contingency on their employment. If one of your employees' right to work is time limited or conditional, for example, if somebody is employed on a spousal visa, you should be regularly monitoring expiration dates and any known impacts of the conditions of the visa. For example, if you're aware that someone is working on a spousal visa and has been divorced, then this will affect their right to work status. Ensure you conduct any follow-up checks before the visa is due to expire and to ensure that the express right to work is maintained. In the event that you do become aware that an employee's permission to work in the UK has expired or is due to expire, and where it would be illegal for it to be continued to employ them, you have to take some sort of action, but you need to balance that out. The need to prevent illegal working has to be balanced out with your employment law duties towards the employee. Simply moving to dismiss somebody who loses the right to work in the UK could be seen as an unlawful act, particularly could be an unfair dismissal with discrimination if they have more than 2 years service. So where you are reasonably satisfied that by the date on which that employee's current visa expires, they had either submitted an in-time application for an extension or a variation, an application for an appeal or administrative review of a decision, or have presented information indicating that they are a long-term lawful resident of the UK and they'd arrived in the UK prior to 1988, then the employee is likely to be able to continue to work for you for an interim period of up to 28 days, even though it appears that the original permission to work has expired. You should be making good use of that 28-day grace period to investigate the situation, including contact to the employer checking service, which we've previously given you the website for, to try and establish whether or not the employee does retain valid permission to continue to work in the UK and remain in the UK and therefore continue in their current role. In the event that you discover that the employee no longer has or perhaps never had the right to work in the UK, you do need to consider taking the appropriate action. Given the potential for civil or criminal liability of employing an illegal worker, most employers in this situation automatically jump to termination. However, it's really important, excuse me, that knee-jerk reactions are avoided at all costs. And there are a number of issues that must be considered before dismissing an employee who you consider no longer has the right to work in the UK. You should always investigate to establish the finding of facts, especially important if they have length of service, which gives them the right not to be unfairly dismissed. You would need to consider if terminating on the grounds of loss of right to work would be a fair reason for dismissal, and always make sure that you follow a fair procedure. That's not to say that dismissal is not a potentially fair outcome. The law does say that dismissal on the grounds of continued employment that would result in the contravention of a statutory duty or restriction, i.e. that it is illegal, would be a potentially fair reason for dismissal. These are sometimes referred to as statutory ban dismissals. An example that I can give you of that is Kelly versus University of Southampton, which was at the Employment Appeal Tribunal, where the employer believed that the employee's right to work in the UK had expired. Following discussions with its legal team and the Home Office, the university decided to dismiss the employee without notice on the grounds of illegality. The employer did not consult with the employee and failed to follow a proper dismissal procedure. It subsequently turned out that the employee actually did have the right to work and the employer had been wrong in its belief, and the employee was successful in claiming unfair dismissal. I've just jumped forward a slide or two. Just come back, sorry about that, a bit trigger happy with the finger. Another potential fair reason for dismissal is, some of you will be familiar with this, which is the some other substantial reason, or SOSA. And another example of that is in Baker versus Abellio London, where the EAT held that the dismissal could be for some other substantial reason and fair, even though the employee was not subject to immigration control. The employee had failed to produce the required documentation, and the employer believed it would be breaking the law if it continued to employ that individual. So the lesson really is to follow a fair process every time and avoid a knee-jerk reaction to dismiss. So based on the new guidance, you should be taking up the following 5 actions. This is what you can be doing right now after the event today. The first is to update your internal policies and procedures that relate directly or indirectly to right to work checking. Reviewing your internal policies that relate to right to work, for example, recruitment and selection, or right to work or termination policies, to ensure that they reflect the updated requirements and best practice for right to work management is a really positive step forward, and something that everybody can step away from today and do. Establishing clear written procedures for managing recruitment and selection based on equal and fair treatment for all applicants, and ensure that these are available to all relevant employees, particularly hiring managers. It's really important that they are fully briefed on the procedures. Ensure that your policy includes a process for checking e-visas online via the Right to Work checking service, and these will become increasingly more relevant in the coming weeks and months. Not making assumptions about a job applicant's right to work in the UK or immigration status on the basis of their colour or race, nationality, or ethnic or national origins. These are all covered under the definition of race in Section 9 of the Equality Act 2010, nor that they are making decisions based on the length of time the person has been in the UK. Going back to my example, the person's been here forever, they're clearly British, it's not a problem. Ensuring prospective job applicants are not discouraged or included, either directly or indirectly, because of their personal appearance or accent. So declining somebody because you assume that they may not have the right to work. Your policies should also be giving permission to ask questions about an applicant or employee's immigration status only where this is necessary to determine whether their status imposes limitations on the length of time that they are permitted to work in the UK or the number of hours they're entitled to work. For example, it is legitimate to ask somebody who is on a student visa how many hours that they are entitled to work in the UK. Your policy should also have inclusions around treating all job applicants fairly and in the same way at each stage of the recruitment process, and deciding at what stage of the recruitment process to request evidence of the right to work. This could be at first interview stage, second interview stage, or only on the offer of it when an offer of employment has been made. In any event, it must always be before the first day of employment. Your policy should be ensuring that everybody is treated consistently, and if one applicant is asked for evidence indicating their right to work in the UK at a particular stage of the recruitment process, then all applicants should be required to produce such evidence at the same time. No assumptions, obviously, should be hardwired into your policy, that not assuming an applicant who is not able to produce appropriate evidence is living or working in the UK illegally. You have to follow that finding of facts route to ensure that before you kind of come to that conclusion. The second stage is providing all your relevant employees with training on the updated right to work requirements, not simply giving them a policy and expecting them to have read it and fully understood it, but maybe having a group session where you can talk to your hiring managers about what the relevant law is, and ensure that anybody who does conduct right to work checks has a strong familiarity with the documents for checking right to work and also the process. The third stage is to ensure compliant right to work checks have been carried out for all employees. So right to work checks for all existing employees need to have been conducted in line with the applicable guidance when the check was carried out, to make sure that the statutory excuse is maintained. So if in the past you've done right to work checks and you've followed whatever the guidance was set down at that time, then you will be protected. If you have done right to work checks but you haven't followed the guidance that was in place at the time, then you may be liable for that statutory excuse to be eroded. If your checks were carried out on existing employees and you're concerned that they may not have been compliant, or you're not sure whether you'll be able to check if they were or they weren't, then a repeated compliance check can establish that statutory excuse now, and the Home Office would accept that. There are a bit of a cautionary note around that. If you have long service employees, then you need to explain the reason for the requirement for checking their right to work. Explain it's for compliance, explain to them that you need to ensure that you have all the relevant documents on file to establish this statutory excuse. This should really be done sensitively and consistently to avoid causing upset or giving rise to complaints. The final stage in all of this is to ensure that you are implementing, so it's not the final stage, the penultimate stage is to retaining the copies of all the right to work checks that are carried out. And the guidance requires you to retain a copy of all right to work checks that you conduct for the duration of the employee's employment and two years thereafter as a minimum. But you must ensure that you are checking that with your own documentation to make sure that it's compliant with your own document retention policy and data protection guidance. The fifth point on this side is implementing a monitoring system. Now, lots of organizations do this already, and that's fantastic, but lots of organizations don't. They do the right to work check at the point of recruitment, and then they don't go back and look at it again. So implementing a monitoring system for all time limited and contingent right to work documentation and conducting reviews with the affected employees ahead of the expiration date is absolutely critical. Robust monitoring of those time limited or contingent right to works will ensure that you are ahead of any potential expiration and sorry, excuse me, and can mean that you're ahead of the curve in terms of checking that the person's right to work is not about to expire and cause a problem. So checking back on the agenda for today, as I'm absolutely bang on time, which is kind of amazing and gives us plenty of time for questions and answers. I'm just going to touch back onto the agenda that we set out at the beginning of this webinar as to what we were going to cover. So the reasons why we need to check an individual's right to work. Well, every employer has a duty to ensure that they are preventing illegal working. So that means that every employer has to conduct a right to work check because you know the person, because you're familiar with the person, because you know their family or you know their friends, doesn't make it that you can bypass the right to work checking. Everybody needs to be checked, and that they need to be treated fairly and equally in that process. 6th of April 2022, changes that came in. The biggest one was the removal of the BRP, BRC and FWP, the permits that we used to be able to use for right to work proving, which we are no longer able to use. You can still look at those documents, but you are going to have to run those individuals through the online checking service. British nationals and Irish nationals, or those with an Irish passport card, can also be put through a manual check or an ISDP check to prove right to work, but they are not able to be, those ISDPs cannot prove right to work for non-British or Irish nationals currently. Being consistent and compliant, not doing one thing for one group of people and something different for everybody else. Having a policy, having a process and making sure that everybody's familiar with it means that you will be meeting that Home Office requirement to be consistent and compliant. And understanding what you need to do if an employee loses the right to work or didn't have it to start with. We talked about avoiding the knee-jerk reaction, not moving to dismiss as a first port of call, but ensuring that you've gone through a robust and thorough process of checking, whether that means getting a positive verification note so that you've got that 6-month buy to conduct further investigation. And only when you have exhausted all the options should you be seeking to dismiss an individual on the grounds of either some other substantial reason or under the statutory banner that I spoke about before. And for existing employees, if you have people working in your organisation for whom you have no right to work documentation, perhaps because they are family or friends or they've worked with you for a very long time, then sensitively but thoroughly, you need to go back to those individuals and ensure that you are able to obtain the right to work documentation and keep that evidence on file. I undertook this exercise myself when I was working for a previous employer, and the Home Office decided to call in on the 4th of January, very helpful, to let us know that they were coming in the same week to check our right to work status for around 1,200 employees. and they turned up two-handed. They usually turn up two-handed. They normally adopt the sort of good cop, bad cop routine. And they looked at over 500 right to work documents in the folders. They took copies of 250 of those, and they took those away for further investigation. Happily, because we did have a very robust system, they came back to us with a nil return. There was no evidence of illegal working. And in fact, they commended the organisation for its thorough and robust approach, which was music to my ears and made me think, actually, you know, that was a really good thing that we did, even though it was quite complicated getting it set up. It did give us that protection against any further liability. So thank you very much for your attention. And I would like to now open the floor up to questions. So feel free to unmute your mics.
We've got some questions in the chat that came up during the conversation. If we can look at those first, is that all right?
Yeah, sure. Yeah, absolutely.
Cool. So the first one was from Heyman Group. Is that Claire? Is that South African national?
Okay. Yeah.
Claire there.
And
claiming that? Okay, so basically we have a South African national who started with us in the last 2 weeks. They provided a biometric residence card, which had a technical fault, so they could not receive a share code. We were advised to complete the employer's checking service on the Home Office website. However, we are struggling to receive a response from them. Right.
Okay. So the first thing is the biometric residence permit is no longer supported, and that hasn't been since the 6th of April. So that cannot be used to prove right to work. You've done all the right steps. You know, it's not jumped to conclusions that, you know, because they've got a fault on their card, then there's something clearly wrong. But you are, you know, obviously you're taking cautionary steps, which is really what the Home Office would expect you to do. If the employee checking service, when you register with the employee checking service, it's almost like you're giving yourself a little bit of protection there, because you've got evidence to say that you have requested the information. If your offer of employment is contingent on them having the right to work, don't forget that you do have the opportunity to hit the pause button at that point until you get a response from ECS. If you haven't had a response from ECS yet, then, you know, I would certainly start thinking about chasing them up. Now, I do have to tell you that they are, like every government department, they are incredibly slow at times because they're massively stretched. So you may need to just be a little patient on that. If the individual has, you know, any other documentation, or if they're able to resolve these matters themselves, because don't forget, you have an obligation to check the right to work, but your employee has an obligation to get their issues corrected as quickly as possible. So it's not a one-way street, basically. So you can continue to employ them whilst you're awaiting the outcome of the ECS. That does give you that sort of level of protection at this point.
And then that was followed up by somebody saying they were in the same position, but they also said they're also a fully remote business. So I don't know if there's a lot of those at the moment, isn't there?
Right. Okay. Well, that I mean, don't forget, until the 30th of September, you can still conduct the adjusted checks. They have extended that facility until the 30th of September. Whether that continues beyond that date, it's anybody's guess right now, but it may well be that they'll extend it again, because obviously for a lot of organizations, you know, the pandemic has fundamentally changed how people operate. So, you know, in-person checks may not be things that are acceptable or even possible. And certainly I had discussions in my previous organization about how right to work checks were going to be conducted, and whether people were going to be expected to, you know, send in their documents and under registered post, and how we were going to conduct that, which is all madness and insanity, really. So at the moment, the government is very adamant about the routes, which is the manual in-person check, the online check, or the ISDP checking. Now, whether they expand out the ISDP check, which would be another way of getting those documents checked, is to be decided. My best guess is that they will possibly extend the adjusted checks activity, so that you would be able to do those checks remotely. And then when the person starts with you, they would have to present at some point the actual documents. But it really is a watch this space right now.
sorry, Future Forest, did have an expansion on that. Did you want to say that?
If you wouldn't mind, that's great. So my only concern at the moment is we're all good for and we've got a process in place, which is great, but we've got new joiners and one has slipped through the net, unfortunately.
Right.
So we have a Nigeria employee that joined us last week. They are on leave to enter BRP. We have their passport, their NIN and their BRP card, and it states that they're allowed to work 20 hours in term time. So currently they are only working 20 hours for us instead of the full time that we applied for. We are currently working with the Home Office to get a license to be able to obviously sponsor the visas. However, we're also going through a demerger. So when we go through that demerger, the license will have to reapply for it under the new business as well.
Fantastic. Yeah, excellent.
So are we meeting the requirements if we keep this individual on the 20 hours until we go through that demerger and then apply for the license then?
Right. It's not the hours that's the issue here. It's whether they actually have the right to remain in the UK and work. So they may have the right to remain in the UK or to live in the UK, but that doesn't automatically give them the right to work. It really depends on the validity of their documentation. So the BRP from the 6th of April is no longer something that you can rely on. You should be putting them through the online checking service to see that whether the online checking service returns that right to work return, basically. If it doesn't come up on the right to work website, then you would need to go to the employer checking service to make sure that the person has the right to be in the UK to start with. So that identity check is really important, and that will also tell you whether they have the right to work in the UK and under what conditions. At the moment, you may be on shaky ground if you haven't done either of those steps, because what your the obligation is basically is that you should be doing, if you do it now, at least you're taking the steps, as opposed to, this should have been done before the person was employed. But yes, the demerger is going to be a problem, obviously, from your sponsorship point of view going forward. Even if you have a sponsorship license, you are still going to have to go through, proof of right to work, even with those people that you're sponsoring, and obviously monitoring and maintaining those going forward. But right now, I would really strongly recommend you go through the online checking service using their passport documentation, BRP, to make sure they have the right to work. If that gives you a nil return, go to the ECS and check them there.
And what is the link to that? Sorry, is that
Julie should have. Yeah, there's two. There's the people get a bit confused between the online checking system and the ECS. They're two completely separate activities. The ECS proves identity and right to work. And this is primarily used where somebody has either not got the documentation or is on some sort of application appeal basis, or the online checking system, which is the proof of right to work. Now, you should really be starting with a proof of right to work. If they haven't presented you with an appeal document or a variation document to say that they are currently out of time and they're going through some sort of process with the Home Office, then assuming they've come to you legitimately with a passport and some sort of evidence of right to work that is now unfortunately no longer valid, you will have to start off with the online checking service to make sure that they have the right to work. We
are going to send around the links again after the meeting on an email. So once we've done that, again, if you've got any questions, just come back to us after that.
And I do appreciate it's really challenging in this day and age, where everybody's absolutely desperate for people to come in and work. And it's always been the case that, checks may not always have been as thorough as they might. I used to work in the care sector myself, so I know the challenges, for trying to find people to come into that particular sector. And we did have somebody who came in on a student visa. And it turned out that they were not attending college. They were holding down at least 4 jobs, all doing 20 hours in different employers, and they didn't have the right to work, and the Home Office were very cross, shall we say, about that. So it is just one to be really alert to. So definitely put them through the online checking service now. And if that gives you a nil return, try the ECS. And if that gives you a nil return, then you're probably looking to a potential dismissal under statutory ban or some other substantial.
Okay, fab, thank you.
We had a question in the chat from Yvonne Ritter. Yvonne, if you're still here, did you want to do that, or do you want me to read that out?
No, that's fine. I was just asking, with regards to obviously new employees, you're saying that these checks need to be undertaken prior to the new starter beginning their first day. Obviously, if we've done interviews, are we able, even at that point, if we're not actually offering a position, to ask to see their proof of right to work? Is that actually allowed?
100%.
And can we take a copy of that to sign and date, as you say?
Absolutely. Yeah, absolutely. Okay. So there's two things that are really important. You know, if you're doing volume recruitment, you can't always kind of, you know, or any kind of recruitment, the obligation is that they can't turn up on day one and go, here's my passport, because automatically you're in breach. So it has to happen during that recruitment process. Where that happens in the recruitment process is really down to you. And that should form part of your policy. So if the Home Office were to come in and say, well, where do you do it? You can go to the policy and say, right there, we do it at the first stage. Okay. So asking for people to come to the interview with their proof of identity and their proof of right to work. Somebody recently said to me, oh yes, no, we did the proof of work. You know, they gave us their driving license. And I said, well, that isn't a proof of right to work. That just proves who they might be. You know, identity documents, so things like mobile phone bills or utility bills or driving licenses only prove address and potential identity, not right to work. So you can say to them, bring both, bring your proof of identity in the form of a driving license, a utility bill, or something else that over from the last 3 months, so that you can prove their address. And we want proof of your right to work in the form of, and you can set out, you know, for example, a passport, you know, and then for British nationals, Irish nationals, the sort of documents that you would accept there. And they would come to you on that first day. You would, I mean, the way that I used to work it with my team was that while they were being interviewed, we'd be checking their right to work, because otherwise they're slightly awkwardly standing there while you go, I'm just going to go off to have a little look at this in closer detail. But we always did that prior to anything else. And if we've got that documentation, we hold that on file. If they are successful, that transfers over with their appointment documentation. If they aren't successful, then organisations have to hold documentation for up to 6 months post unsuccessful interview, because within that 6 months, an individual can bring a claim for discrimination within 3 months, and that can be extended up to 6 months under special circumstances. So whether you hold that in a digital file on your system and then timestamp it so that 6 months in it flags up and you just delete all of those documents, that's really for your internal processes. But yes, you can ask them at interview.
When else would be a suitable time? Because obviously once you've interviewed somebody, then it's sort of that onboarding period where, yes, you could ask for the document to be scanned over, but that's not substantial enough, is it? You're saying we need to physically see those documents.
You've either got to, at all points, unless you're using the adjusted check, which you can still do up until the 30th of September this year. Hopefully it will go on beyond that, but at the moment they've just extended it to the 30th. Assuming that does end on the 30th of September, you've got 3 points of checking. You've got the adjusted check, which was introduced during the pandemic, which is the remote hold, you know, they send you the scanned copy, then they hold it up by their face, and then, you know, you make sure that you've written on the document, you know, this is an adjusted check. That provides you with your statutory excuse. Or you do a manual in-person check. So, you know, it's a British Irish national, and they've got a passport or a passport card, and you're able to do that manual check with them physically present, so that you can look at the passport, look at them and say, yep, these two things marry up. Or you can use, for British and Irish nationals, you can use that ISDP. If you haven't got one of those, don't worry about it. And for anybody else who is a foreign national worker, you can put them through the online checking system. That's all free.
And with the online checking system, or the ECS, we have used that for employees here. Obviously, if they send us through the details and the share code, we don't physically need to see the document at that point, do we?
You should still be looking at the physicality of the document if you can, because obviously, you know, a share code is only something obtained through the Gov site. you still need to make sure that the documents they're coming in on are not fraudulent, and that the person who actually then does turn up for employment is the person that you're looking to recruit. So ideally, you should be conducting physical checks of documentation and then putting it through a checking system. If you're interviewing them, obviously if they're remote interviews, you can ask for the share code, date of birth. That will give you a statutory excuse. But obviously, as soon as they start work, it would be worth doing a retrospective check just to make sure that the person is who they say they are, and that wherever they're working in your organisation, you've done a physical check thereafter.
Cool, thank you so much. I'm so sorry, just one more really quick question.
Okay.
If we've recruited somebody from an agency, are you guys as recruiters liable for obtaining the information and as providing proof that the candidates you're supplying are legally allowed to work in the UK?
No is the answer.
Okay.
because they're not our employees, so it's an employer's obligation. So an agency has as a duty to check as best they can, same with anybody else, but they aren't actually going to be working for us as a company, and it's the employer that holds that burden of proof, burden of liability. So if an agency has said, oh yes, absolutely, we've done all the checks, they're lovely, away you go, and you don't do anything else, you've already tripped up at the first hurdle, because you don't know that your agencies have conducted that in a consistent, compliant way. It may be different to how other people within your organisation have been treated. So my recommendation is always, if the agency says yes, they have the right to work, say thank you very much and conduct your own.
Lovely, brilliant. Thank you for your help.
You're welcome.
I'm still going. Is that all right? I've got
Sure.
Suzanne Duncan had a question. Is Suzanne still here?
Can take probably just one more maybe, and then
okay. So Suzanne said, if HR is not based in the same office as a new employee, can we rely on the local manager to check the right to work documents, as long as they email to confirm that they have seen the originals and any photo is a true likeness?
Okay, so true likeness is not necessarily the issue here. It's the permission and the authenticity of the documentation. So if you have local managers who are conducting right to work checks, then you have to ensure that they are trained, that they understand and are familiar with the policy and the process, and that they are familiar with the types of documentation. So this comes back to educating managers on what to do, how to do it, and why, so that they're not skipping over stages. Because if you devolve that responsibility out, which lots of organisations do and are very successful at doing that, you've got to make sure that they are an extension of whoever has the most knowledge. So if HR knows the most, it has a responsibility to ensure that the managers have that same degree of information and knowledge, so that statutory excuse is maintained. So yes, you can devolve responsibility out to others, but you have to make sure that they are trained and equipped and able to do that right to work check, and that all the same process steps, so ensuring that they have checked things online, check that it's written by the side of it that they have conducted the check and the date that it was conducted, all of those stages still applies, but it just be done by somebody in an office outside of your core HR rather than the HR team itself.
That's great. Thank you, Gemma. I think that's all we've got time for today. So did you want to wrap up, Gemma?
Yes, absolutely. So let me just get to the last slide. So obviously, thank you so much for everybody who has come on. I know we've gone over a little bit, but there were some absolutely amazing questions, and I think we've got quite a lot more. So we're going to be looking at those afterwards and making sure that we pull together responses to the questions, and that will go out to everybody as well. So there's more information to come. A copy of the slides and also the websites. If you didn't get a chance to kind of grab the websites as they came through, I know there was a few of them, but those will also be dispatched out. And that the intention is to put a recording of this webinar onto our website, that you will be able to access via our website, which is the kingswood.org website. If you do have any further needs for HR advice around this subject or any other, please do get in touch with us. The contact details are on the slide, and that we will be doing other webinars throughout the course of this year and into next. So again, those titles will appear on our website, and if you do wish to subscribe to those, please feel free. We'd be more than happy to have you along for the sessions. So thank you very much for listening. I really appreciate it, and I hope everybody's been able to come away with some practical tips and guidance around right to work checking.
Great, thanks, Gemma.